All right. Hi, Julie. No, can't hear you.
There we go. Okay,
Hi, how are you?
good. How are you?
Good, doing great. We have just a couple more minutes before we get started, but I just wanted to let everybody who's on know that we are on schedule to start at 11 and have a really information-packed program today. We're excited to give it to you.
Yeah, thank you all for joining us today. I know that this is a hot topic, and a lot of you are going through a really tough time dealing with a narcissist in a family law case. It's certainly some difficult waters to navigate. And so Billy has worked hard to put together a really helpful and compelling presentation to walk you through this challenging path.
Yeah, it's been quite a journey to figure out how to package all of these years of experience and many different iterations of going through cases with people to figure out how do we package it and give it to people who are representing themselves. But even though it's taken a lot of work and a lot of years, we've managed to figure out a way to shortcut it for people, which is great because now you don't have to go through the decades that we've gone through and the many cases we've gone through to learn all of the lessons through mistakes. So that's kind of exciting.
Yeah, it's kind of an ongoing learning process.
Right. And, if you can shortcut that learning by learning from other people who have already done it, who've already learned it, that's always a great thing because navigating these cases is really hard.
It is really hard. And, most people have been manipulated by the narcissist throughout their relationship. And it's hard to step out of that programming and start to communicate and interact in new ways, which um, is really key. If you're going to keep doing the same things, you're not going to really change the situation. So we're going to talk about some tips and tricks to help you start to change up the dynamic.
Absolutely. So it is now 11 o'clock. We will get started. Thank you all for being here. Thank you for joining us. This webinar is developing a strategy and winning your case against a narcissist, finding solutions that actually work to protect your peace. My name is Billy Tarasio. I am an Arizona family law attorney. This is Julie LeBenz, also Arizona family law attorney. We are the co-owners of Win Without Law School. We have both been practicing almost 20 years. I guess we're at, a combined 35 years plus. And we founded Win Without Law School in 2022 to help people represent themselves. This has been a long journey for us. Do you want to talk a little about that?
Yeah, both Billy and I, before we even knew each other, had this passion to try to help people who can't afford a lawyer or don't want to spend the tens of thousands of dollars it costs to hire a lawyer, and in particular, to fight a narcissist, because that can be some of the most expensive cases to face. And we wanted to help people navigate the family court system. And Billy and I are different because most attorneys think you can't do it on your own. And of course, we want to be honest with you. It's not easy to figure out how to do it on your own, but we believe and we've seen that with the right information, and if you're willing to put the time in, you can have success and you can save on those tens of thousands of dollars. So I know Billy's created a lot of different products over the years. I have too, but Win Without Law School has been kind of the product where we've both gotten the most traction and been able to help the most people so far.
Absolutely. And you may know that 80% of people in family court represent themselves. And you probably know that hiring a lawyer can be cost prohibitive, especially when you're in a case for 10 years plus, which often happens in these very high conflict cases. So figuring out a way to provide an alternative to the traditional one-to-one attorney-client model has been absolutely key in increasing access to justice. So there's a couple things that you should know. You already know that we are Arizona family law attorneys. We are not your lawyer. We are not giving you legal advice. At no time in Win Without Law School do we become your lawyer or provide you legal advice. We are coaches. We are here to teach you skills, to give you ideas, to give you strategies, to offer you feedback and tips and tricks on how to make you better. So it's a very different relationship. We do not become your representative. We are here to be your coach. We can't guarantee any outcomes. What else do you need to know? We have our own family law practices, and nothing about you coming to Win Without Law School creates a conflict because we're not in an attorney-client relationship. So you should know that if you are an opposing party to one of our clients at our law firms, nothing about you showing up at this webinar is going to be able to conflict us out because we're not your lawyer. I think that's it. Any other disclaimers we need?
No, that was great. You hit all the points.
All right, well, let's dive into it. I want you to meet Elena, or Elena, might be Elena. Elena was a client of mine in a very, very difficult case. She came to the United States when she was a young adult, maybe 17 or 18 years old, and she came to be an exotic dancer. And she found herself working for David. David owned the strip club that Elena was working at. I've changed her name, so we can call her Elena or Elena. It's not actually her name. But she ended up working for David. She ended up marrying David. She ended up having a child with David. And as you can imagine, the power differential in that relationship was a pretty unhealthy one. David was a lawyer. He was a lawyer in California. He had become disbarred in California and could no longer practice, but was still owning businesses, operating. And it was a pretty horrible relationship. It was a relationship that turned abusive. And eventually she got out of that relationship. She divorced David, but that started a war. She had chosen a war with a man who knew how to go to war. And by the time she got to me, he had already sued her former lawyer, sued her former nanny, sued her personally, and we had ongoing family law litigation. He had a drug problem. He, of course, said she had a drug problem. He did everything he could to drag her through the mud. And he was seen as a smart, rich, great dad, great husband. He wanted to be seen as the rescuer, and she was the one who was in the mud. So he ended up coming into my office, and she was in my office, and he was not represented. And I used all of the tactics from Chris Voss's Never Split the Difference. And because I was new, he didn't hate me yet. And I was able to build enough trust and goodwill to negotiate a deal for them that would get them out of family law litigation for the moment. Now, the thing with narcissists is, you're never out forever. There is no agreement and no deal that is going to be the end of the fighting. It simply won't work that way. But we figured out how to get her out of the situation, how to come up with a parenting plan that offered her enough protection and enough boundaries and enough accountability so that she could enforce that parenting plan. And this was only chapter 1. She went on to represent herself for many years, and I was her coach. I helped her navigate her very, very difficult, long-lasting journey, but she did the work. She learned family law. She was very organized. She set boundaries and kept them. Think of this woman as your quintessential kind of Eastern European. She knew how to set boundaries, how to be firm. She knew how to work hard as an immigrant, and she did fantastic navigating against a very, very difficult ex. The moral of the story is there is a formula. You can do it. Narcissists. Narcissists are not normal. They think that rules don't apply to them. They think they're smarter than everyone else. They're incredibly sensitive to rejection, and they're intent on punishing you for the ultimate betrayal of leaving them. They like to be the victim. They love to be on stage. They love receiving the attention that is court. They gaslight all the time and make you constantly question your sanity, hating the version of yourself that you become around them. Litigating against a narcissist is not normal, but it is predictable. You need to have a strategy. You need to understand that while some divorces are checkers, you're chess. You are in the long game where things are very, very complicated. And you have to constantly be thinking about, how is this going to affect me long term? What will the long-term solution look like? There's no simple solution, and the court system is never going to provide you the relief that you're looking for in the time frame that you want it. So what is it that you can do? We have broken down the formula of dealing with these types of opposing parties into 3 basic rules. And the 3 basic rules that we're going to talk about today and teach you today are enforceability, making sure that you have a plan, whatever it is, a decree or a parenting plan that is enforceable, parallel parenting, and mindset issues. For me, these tips and lessons have been hard fought over many, many years of litigating against narcissists. It's taken hundreds of hours and trial and error to learn what we're going to show you. For enforceability, you need an enforceable parenting plan and a decree that is lock solid. To be enforceable, it must not be subject to interpretation or be ambiguous. It should have practical protections in place that separate you from your ex. You want to create as much separation as possible. And you must ensure that your provisions can't be weaponized against you. If it's too detailed or the plan doesn't age well, it could be used to harass you or take away your authority. One example of that is the right of first refusal. That is often one of those provisions that can be weaponized against you. But if you haven't gone through hundreds of these trials and hundreds of these cases, you may not know that. And it's very hard for people who are representing themselves to know what to put in their parenting plans and decrees because they don't have the benefit of knowing how these provisions play out many, many years later. We have that benefit. Parallel parenting. You want to create distance and space for a plan that will allow parallel parenting. Exchanges should happen at school. The receiving parent should pick up. There should be an order for curbside pickup and an order with limitations on communication. One of the things we're going to give you today is a download that I created based on what judges and parenting coordinators have ordered in these types of cases. So it's inspiration for you for your parenting plan or your decree on communication guidelines. You want to create distance and space. Communication should be through your co-parenting app because it slows down the communication. It reminds you that you're creating exhibits. You want to plan ways to keep your children safe from conflict, and that's where incorporating parallel parenting can be an absolute godsend. Conflict needs oxygen, and you must remove the oxygen. It's the best way to protect your children. You also need provisions regarding your property division or your support or enforcement that are very detailed and clear. You cannot have the normal provisions like retirement accounts divided via quadro. That's a provision that Julie and I have seen 1,000 times, and we can put that in some of our divorce decrees, but we cannot put that in divorce decrees with very high conflict or narcissistic exes. The house goes to dad, who will refinance and buy out mom, is not a provision that you can put in your decree if you are dealing with a narcissist. There's too many, it's ambiguous. There's no deadlines. There's no what happens if. And the final pillar here that we're going to talk about is a mindset shift. You are giving up a lot of control by divorcing, especially if you have kids. You're not going to get to raise your kids exactly the way that you wanted to. You have a new constraint that is cooperation, and your ex will weaponize that against you. I hope I'm wrong. I hope I'm wrong. I hope you don't have to deal with this, but this is what you need to plan for. And so even if you get sole legal decision-making, the narcissist can sabotage your decisions. They can put your children in the middle or try to turn your children against you. They can mess with the minds of the people around them. Sometimes they will sabotage your job. And while it's tempting to think that the court can make them behave, the court cannot make them behave. The only thing a court can do is enforce an order, which is why we want the order to work practically, and we need it to be enforceable. We need routines that work, that create separation. Unless you have a trust fund for legal fees for the rest of your life, you will need to learn to do this on your own. Even if you work with a lawyer, you will need to learn to take some of this on your own and to navigate this, because you cannot call a lawyer every single day for the next 10 years while you navigate this conflict. You have to become your own advocate, your own strategist. Secret number 1. Julie, you want to take this?
Right. So if you're going to represent yourself, then it's critical that you put in the time and the work to educate yourself about the law and how to go to court. Because if you just cross your fingers and hope that things are going to work out, you're likely going to get blindsided and taken advantage of. Because if the narcissist is able to show up in the court and be very convincing and tell a story, and you aren't prepared, the judge is only going to go off of the information the judge receives. So if the judge only hears compelling evidence from one side, the judge is going to be more likely to rule in that side's favor. And it's also critical to know what type of hearing has been scheduled. What do you need to do to prepare? What are the associated deadlines? What's going to be the procedure for that hearing? There's a lot of preparation that goes into representing yourself. Not every court date is the same. Not every type of hearing is going to involve testimony and providing evidence. Often people go to court and they don't know what the type of hearing is. And then when they try to testify and the judge says, no, we're not going to do that today, they leave the courtroom thinking the judge is biased against them. But that's really not the case. It's just that wasn't the type of hearing where evidence is presented. So the judge is really just following the rules, but often a self-represented party will misinterpret that and think that the system's against them. So it's going to take some time. And this is where we have created a database of resources within Win Without Law School to help you learn how to do this on your own.
How must you show up in court? There is a formula for success. There are rules and there are customizations. Nothing about this is quick or easy or one size fits all. There's no uniform parenting plan for every situation. It has to be customized to you. But there are certain things that are true no matter what. You must show up in court organized, focused, calm, rational, kind, respectful, and you must put in the work if you're going to be successful.
So secret number 2 is that, I'm just finishing up answering some Q&A. Learn from decades of experience and thousands of others who have already done this wrong. Many people are naive about how to deal with the narcissist and maybe just think, oh, the judge will get it right. The judge is knowledgeable, the judge knows the right thing to do, and the judge will figure it out. But you need to provide the judge with the tools to be able to rule in your favor. You need to be able to present compelling arguments. And like Billy talked about earlier, it's a very common strategy of the narcissist to take all of the bad things that the narcissist is doing and point the finger at their spouse or co-parent and falsely claim that they're the ones doing that. And so you're playing this game where you're not only making sure you're defending against all of these allegations, but then you're also making sure that you're putting in the time and effort to make your allegations against the other side. Because if all of you're doing is defending, then you're not telling the whole story. So it's really this delicate balance of figuring out how to defend and also how to put forth your positions and your side of the story in an effective way.
Rules of engagement. If you have children, we're going to talk about rules of engagement for both with kids and without kids. First, with kids, you want to minimize your interactions and you want to minimize your exchanges. Weekly exchanges are generally better than a 5225. A simple holiday schedule is usually better than a complicated schedule. If you start putting into your schedule things like birthday time gets split or days getting split, you're creating more interactions more interactions means more conflict. Why? It's more oxygen. So when you're creating your parenting plan, simplicity and minimizing exchanges should be one of your top priorities if you're dealing with this type of person. You also want to use third parties wherever you can, like parenting coordinators or appointed co-parenting counselors, for accountability and assistance. Simple and specific is best. You want to avoid the need for consensus. The status quo can be powerful, and use of a co-parenting app should be non-negotiable. It's really, really useful in creating some accountability, creating some organization, creating exhibits, and as I said earlier, slowing things down. It's harder to log into a co-parenting app and respond to an email. One thing that I would even recommend is when you have a non-emergency email, waiting a minimum of 24 hours before somebody responds. Your response after 24 hours is going to be better than your response initially to a charged email. So putting plans and procedures and things in place that create what you need in terms of structure and distance is a great thing. Rules of engagement for no kids. Exchange of money should be remote. It should be through attorneys, through the clearinghouse, or through something like Zelle. It should be automatic. The clearinghouse is best. Have your titles ready to be signed when you're getting divorced. So if you're entering into a divorce decree and you're agreeing on things, think ahead before you just say, oh, I'm going to be done. Think ahead before you sign and submit that divorce decree. Try to transfer all of your car titles, all of your home titles, everything you can. Close all of your joint accounts and credit cards. People don't do this. I don't know why. It's because they don't want to impact their credit, but you just got to take the plunge. Like, I can tell you from personal experience, I had a great credit score and my credit took a hit when I went through divorce. I had to get a new car. I had to rent a place. I had to open new credit cards and close the other ones. The score went down, but it came up, and it's the best thing you could possibly do is create that clean break. Do it. Change all of your passwords. It's easy to miss passwords, but you have to change absolutely all of them. If you can get an order of protection and you qualify because of harassment, get the order of protection. Boundaries are absolutely critical when you're dealing with high conflict or narcissistic people. Invest in yourself to create protection for yourself. Secret number 3.
Yeah. Doing nothing and simply hoping things will work out is not a solution. It's time for you to change. Now, this applies not only to your preparation for your trial and for going to court, but also with how you're going to set these new boundaries with your ex or your co-parent. You've likely been, under a spell, really, that this person created that made you cater to their needs, that made you bend over backwards to make sure that everything was the way that they wanted. And you've created these patterns and habits where you are constantly suppressing what you want and what your needs are to cater to the other person. But you're getting divorced or separated or, ending a relationship with your co-parent for a reason. And so it's time to start, number one, being cognizant of those patterns. The awareness is step one. It's not like you're just going to change overnight because you decide you want to. Oftentimes, you're going to need to trip and fall a few times and repeat those patterns before you change. But the spark of change is noticing the pattern as it's unfolding. Because at that point, you start to then have choice. You start to then be able to make a different decision the next time you find yourself in that position. So really be gentle with yourself. Don't expect that all of a sudden overnight, you're going to know exactly how to deal with this person and you're going to show up completely different all the time. This is a process and you're going through a lot. So be really gentle with yourself. But I think the first step is just to start to really have the awareness of how they're manipulating you, how they're controlling you, how they're gaslighting you, and starting to shift with time so that you're cutting off communication, you're using the co-parenting app, you're not engaging with them, you're not getting set up by them, It's really going to be this game of chess, like Billy said, and it takes some time to learn how to play chess. So give yourself that grace to start figuring it out, but also know that it's time to make some changes.
Absolutely. And the other thing to realize is you're not a victim if you decide that you will be one no longer. You are in a relationship dynamic that does require two people to create the dynamic. And the only person that you can change in the dynamic is you. And I totally agree with Julie. That takes time. But there is a lot of power in knowing that you get to show up differently. You don't have to repeat the same negative pattern that you have been with your ex. Mindset shift is going to be really, really key. Parental guilt is the worst, and life will be different for your kids. You won't be able to give them the life that you wanted. This is a big deal. This is heartbreaking for my clients. I see it play out again, again, and again. You won't have as much control over their lives. I've got a friend. They've got a 12-year-old and they are in an intact family, and the kiddo's name is Natalie. And Natalie wanted to play soccer. She was already on a club team and she wanted to play on a rec team as well. And her grades slipped. And her parents together said, nope, you can't play on this rec team unless you get your grades up. You can't do it. And they, as a united front, got together and supported Natalie, their daughter, who worked really hard, got it together, and is now on both teams. I just compare and contrast that with what I see with my clients. It's never that. It's never, how do we cooperate to give our child the accountability and the structure and support that we need in order for them to live their best life? It just doesn't happen. So while you desperately, we as parents want to set our kids up for as much success as possible, if you only have them half the time and you and your co-parent are not on the same page, you're probably not going to get the Natalie result. You're probably going to get mom and dad are not on the same page. There's blame back and forth on whose fault it is that Natalie's grade slipped, and you're going to have less control over the outcome with your kids. You have fewer hours and you have to get 100% of your parenting time done of your parenting. So all of the parenting you want to do has to be done in half the time. It's a lot of pressure. How can Win Without Law School help you if you are navigating this type of situation? Well, one thing I can tell you is I am 1000% certain that Win Without Law School can help you if you are in this situation. We know that because we tested it. We built this program more than a year ago, and we've tweaked it, and we've learned, and we've adapted, and now it is finally at a place where we can say confidently it is 100% working. But it's not just us. You can't just take my word for it. Here's what one of our members says. Billy, you have helped me so much. I got so much value out of your videos and the information that you shared for months before I joined Win Without Law School. While the free TikTok videos were great, the members area of Win Without Law School is a huge step up. I wasn't sure that I needed the membership because you give away so much information for free, but Win Without Law School really puts it all together. Now I have a cohesive strategy, and whenever I hit bumps or new issues, I can get the help I need. Win Without Law School has saved me thousands in attorney's fees and has helped my anxiety. It's still hard, but I am so grateful for the support. Here is the formula to success. Julie, you want to take this one?
Yes. Okay, so in Win Without Law School, we take you through a step-by-step process, and this is through video instruction along with materials. And then we have a private Facebook group where people can ask questions. And we also do a live Q&A 4 days a week where people can come on and ask questions. And when you're going through case initiation, the first step is to create a case strategy. So that's when you're going to identify, what is your requested outcome? What are the disputed issues in your case? And then how are you going to get to that endpoint? One other important question in step 1 is whether or not your requested outcome is reasonable. And that's where participating in the Q&A can be helpful to get some insight on whether what you're asking for is a reasonable request or not. Once you've identified where you want to go with your case, you'll want to start figuring out, okay, what is the law? Because once you know the law, that's when you can start identifying what are the key pieces of evidence to gather so that I can prove the positions in my case that ultimately I want the court to rule in my favor on. In addition to the law, the rules of procedure are really important because that's going to help you navigate to the endpoint. And a lot of people stumble on the procedure and their case gets just kind of stuck and isn't going anywhere because they don't realize that there's certain paperwork to file to start moving the case in the direction they want to go in. Step 4, understand what you must prove to get your desired outcome. So a lot of times people get caught up in the blame game that, oh, she's bad, he's bad, really just getting into this argument about whether or not their co-parent is good or bad, when that's not what is at issue according to the law. Under the law, the best interest standards of the child are what's at issue. And ideally, you have the best interest standards, and then you're incorporating these complaints or allegations that you have about your co-parent into those best interest standards. And now you're not just going into the court and the judge is like, oh, here's 2 more parents fighting with each other. Instead, the judge is going, oh, I understand. I see the best interest standards and how this parent isn't acting in the best interest of the child. So it's really important to take it out of this he said, she said battle and really fit your arguments into what you're required to prove under the law. And that's also going to help you identify and gather critical evidence, because once you know what the law says and what you need to prove, now you can start to identify, oh, this is really good evidence to prove that. Or this one thing that I thought was really important actually isn't, and I only have limited trial time, so I'm going to set that aside and instead focus on this other piece of evidence that's really key. And something else that we teach in Win Without Law School, which a lot of self-represented parties don't know, is how to package your exhibits. You don't want to take a year's worth of text messages and make that one exhibit and just expect the judge to read through a year's worth of text messages. So we talk about what to do with those text messages, how to put them into an exhibit, how to make it compelling, and how to show it to a judge so that a judge is going to listen and pay attention to what you're wanting to show in those text messages. Step 6, you want to take a 2-pronged approach. You want to be actively preparing for trial while also negotiating a settlement if possible. It may seem like reaching a settlement is impossible with your narcissistic ex. However, realize that there's so much to gain through the negotiation process. First of all, you can see if there's any issues you can resolve. Maybe you don't get a full resolution, but maybe there's some pieces that you end up resolving. And that's always helpful because you likely are going to have limited trial time. So as many little pieces that you can get resolved, that's going to give you more trial time to focus on the bigger issues. Additionally, through negotiations, you can get very clear on what's your position on an issue and what's the other side's position. And that's going to help you with focusing your evidence, focusing your arguments, and really making a compelling trial presentation. And also starting to craft persuasive points about why your position is stronger and why the court should rule in your favor versus what the other side's position is. Step 7, understand the rules of evidence to admit your exhibits. Definitely. I can't tell you how many times I've been in court and I've either been up against a self-represented party or I've been waiting for my case to be called and I've been watching a self-represented party in another case. and they have a stack of papers on their desk, and they're like, "Judge, you got to look at these." And the judge is like, "Well, they were never admitted into evidence." And they don't understand what that means. They don't understand what to do. And it's heartbreaking to see. So you really need to understand what the secret language is to tell the judge, and the appropriate time to use the secret language to get your evidence admitted during the trial. Step 8 is to prepare for trial. Now, one really helpful material that we have within Win Without Law School are sample trial outlines. Now, a trial outline is not required by the rules of procedure. It's not in the statutes. You're not going to find it in the court forms. This is something that I use in my cases. And this is something that I recommend everybody generate. You don't need to just share it with the other side. You don't need to share it with the judge. This is your script to use during the trial so that you know what to say when it's your turn to talk. But it takes some time to prepare it. And within the Win Without Law School materials, we have sample trial outlines that give you the framework for you to then fill in your questions, your cross-examination questions, your closing argument, all the key points in a trial. And then if you're a member, you can bring your sample questions to the Facebook group or to the Q&A and get feedback and insights about how to make your questions better, and also how to condense some of your questions, organize them, and get them really focused. Step 9, present your case and preserve your case for the future. So if you are just going to go in with no plan, this is going to be a highly stressful and likely very traumatic experience going into court. Because if, for example, you're the petitioning party, then the judge is going to turn to you first and say, "Okay, present your case." And that is your turn to call your first witness. Yeah. And if you're your first witness, then that's your chance to testify. And if you're really nervous and you just start rambling, then you're not really proving the elements of your case necessarily. And if all you're doing is complaining about your co-parent and how horrible they are, then you're not really meeting the elements of your case. So it's important that you get prepared so that you can walk into that courtroom with confidence. It's not that everything is going to go exactly the way you expect, because even as a seasoned trial lawyer, I never really know exactly what's going to happen when I go into the courtroom. But I got to tell you, it is critical for me to have a plan so that even when those curveballs come in, I'm more prepared for them than if I didn't have a plan. And this is the other thing. If you're representing yourself at trial, you're also going to have an opportunity to cross-examine the other side. And in my experience, unless you are a hotshot lawyer, there's no way for you to plan cross-examination on the fly, because you will likely get to the smoking gun question first, but there's really 3 or 4 questions you should have asked ahead of time to set up the smoking gun question. And that's going to come through preparation and through your trial outline. So really, this isn't easy, but there can be some really strong benefits to representing yourself, because oftentimes judges give the self-represented party the benefit of the doubt. Not always, but often they're kind of rooting you on, believe it or not. And if you come in and you're very prepared and you present a compelling case, the judge is going to be very impressed and maybe more inclined to rule in your favor. But it's going to take some time, some effort, and some education to get there.
What if somebody already has a lawyer? Should they still join Win Without Law School?
Definitely. This can be a great way to save on legal fees, because if you are working with a lawyer on an hourly rate, then every time you ask them a question, they're going to be charging you. So this can be a chance where you can get some preparation, and also you can position yourself to better utilize your lawyer. So that can be really helpful even if you have a lawyer. We do have several members in the group that have lawyers, and they found their membership to be really helpful to be able to focus on what information and evidence to gather to share with their lawyer, and also what questions to ask their lawyer. to help them navigate their case.
What if someone doesn't live in Arizona?
We have members from all over the United States. Definitely our information is tailored towards Arizona law because we're Arizona lawyers, but there is a lot of overlap with different states about the law. And with the way we're teaching you, you'll be able to do some research to find the law in your area on these particular points, and then take what you've learned in Win Without Law School and apply that in your state. But we've had people have success in various different states using the tools, and trial procedure is the same everywhere. So the skills that we're teaching about how to prepare for trial and how to talk to a judge, those are going to apply regardless of what state you're in.
Right. And it's not just that, family law, while slightly different, isn't that different. You have to come up with parenting plans. You have to figure out child support. You have to divide property, and there might be slightly different rules in various states, but the fundamentals are the same. And we are teaching the fundamentals. Now, what if someone doesn't speak well in public, or they're getting very anxious?
So first of all, I even get nervous going into court. So it's normal to feel nervous. It's a intimidating setting, and there's a lot on the line. So give yourself, some grace and be gentle with yourself, because that's normal. But I think having a set script prepared so that you know what you're going to say and you can read from it is going to help you when you're very nervous in court. And then you don't have to come up with something on the fly. You already have it planned out what you're going to say.
One question that a lot of people have asked me is, well, will the lives be too crowded for me to get my questions answered? And we have not found that at all.
Right. Even though we have many members, not everybody shows up to every single Q&A. Some people, it doesn't match up with the time that they're available. Other people are more inclined to utilize the Facebook group. And then there's other people who come to the Q&As every day, but it hasn't been too crowded. But we're set so that we can open up additional time slots for more Q&As if people aren't able to get their questions answered during the times we have set. Also, some questions don't take a long time to answer. So even if there are a decent group of people on the lives, we're able to go through the questions relatively quickly, depending on what the questions are.
The last question here was, what if we don't need a whole year? And we've now offered up monthly pricing as well. So here are our packages. You can become an Essentials member, which gets you access to every single course that I will show you what we have. Also the private Facebook group, also to watch the lives. What you don't get in the Essentials is access to individual or group coaching yourself. So you can't bring your questions to ask them. Now, some members, they are getting everything they need from consuming materials. If that's you, then this is going to be a great package for you. It's $5.99 for an entire year, or $199 a month. In the interactive, you also get access to the lives. That is up to 4 days every single week where you can go ask your questions. There will be times when your case is hot and time when it is cold. And when your case is hot and you're gearing up for trial, you're going to need a lot of feedback. That's when you really want to attend the lives. And that's $14.99 annually, or $2.99 a month. Finally, we have our premium membership, which includes individualized coaching. It's $24.99 for a year. That comes with 4 individual coaching sessions with Julie, or $3.99 a month, where you get 1 session per month for those first 4 months. Now, what exactly is available inside the Win Without Law School membership? Why is it worth what I just told you it costs? Well, let me tell you why. The courses that we have available are divorce and legal separation, establishing child custody, modifying or enforcing a decree or an order, trial skills, contempt of court, representation options, and our bonus courses. We also have planners. We also have that trial binder. There are a few things in Win Without Law School that Julie mentioned that are absolute secret weapons you need to have if you are representing yourself. Now, within this divorce and legal separation, we're going to be talking about property division, spousal maintenance, legal decision-making, parenting time, child support, approaching settlement before filing, how to serve documents, how to respond, how to get a default, temporary orders, disclosure, discovery, settlement, and trial. Within the child custody course, we're talking about parenting time and decision-making, child support, approaching settlement, temporary orders, disclosure, discovery, and settlement. Now, if you are in a case with a narcissist, you likely will go through every single type of case. You're going to first get a divorce, then you're going to need to enforce your order, then you're going to need to modify your child support. So every single course may be relevant to you throughout the duration of your case. Modifications and enforcements are slightly different. So you've got an entire course going over all of that, including things like the simplified child support modification. Sometimes that can be a great tool to get your child support modified with limited contact. Trial skills is perhaps one of our most valuable courses. You can get a lot of information online. It is very difficult to get this information online or this information by yourself. Here, we're talking about building your proficiency in trial advocacy and litigation. You're going to get big picture concepts, how to create a case theme and theory, how to do pretrial statements, how to do trial outlines, opening statements, direct examination, cross-examination, redirect, objections, closing arguments, emotions, expectations, and the rules of evidence. This is a must-have course, no matter what type of case you have. Contempt of court is also absolutely critical if you are up against a narcissist or a high conflict individual. You will need to know how contempt works. And it is nuanced. It is not, many times people wish that they could go to contempt for something that is not contemptible. And we will teach you exactly what is contemptible. Representation options is also something you're going to need to know. Probably there will be times when you hire a lawyer to help you with some pieces. And probably there will be times when you're completely on your own. And you need to know about how to best maximize your budget with the legal system. Finally, we've got bonus courses that are orders of protection, contempt, domestic violence and child abuse, and the rules of procedure. What else? We also offer 12-month planners on a divorce case, on a custody case, expert legal information, Q&A 4 times a week, and individual coaching in our premium. Our community is confidential and members only Facebook. So some of you might be part of the Facebook group that Modern Law runs. This is a different Facebook group. It is members only. You are sworn to confidentiality. Your ex can't get in there. And we're going to get a lot deeper inside what's going on. Today, I also have some added benefits for you. I told you that I put together that communication guidelines. Only those of you who are here today will have access to that. And let's see, I will post that during our Q&A. I will post that in the chat so you can go there and download that. It's 16 phrases to use with a narcissist to acknowledge their position and diffuse the situation, and 30 different communication guidelines from judges and parenting coordinators to create boundaries and create accountability. Now, I think that this program is worth tens of thousands of dollars. You saw our prices. We're not actually charging that. But also for those of you who are here today through the end of the year, you have an additional 30% off coupon you can use. You can go to the Win Without Law School website. You can use the coupon NARC30. This only works on the essentials and the interactive. It does not work on the premium. If you're getting individual coaching, then you still have that $24.99. The last thing I can offer you today is for the first 25 people who sign up today, because we had close to 800 people register for this webinar. But for the first 25 people who sign up today, I'm also throwing in a kickoff call with me before the end of the year. We do have some time for questions. We'd be happy to answer those between now and noon. If you have enjoyed this webinar, please let us know in the chat. Give us a thumbs up. Tell us where you're from, and then we will dive into some Q&A.
Okay. I've been answering some questions in the chat here. Let's see here. I anticipate my ex will not follow a parenting plan. Do you have any tips on ways to structure consequences into the plan to incentivize certain behaviors, such as timeliness for visits, consistency on phone calls, etc., without having to wait for a lack of compliance to go to court?
That's such a good question. It's so on point. So I think things like phone calls inside parenting plans with narcissists should be avoided if possible, because that's one of those things that, in my experience, can be really weaponized. But there are tips on this in that communications guideline. So things like, let me find it. Yeah. Let's see. So there are things in there like the children should have the right to contact the other parent within reasonable limits. Reasonable limits apply to things like frequency and duration. So if you have a provision that says that the children should always be allowed to contact the other parent, I've seen narcissistic high conflict parents weaponize that against the children and the other parent by keeping them on the phone all the time, or not really encouraging the children to behave very badly towards that non-narcissistic parent. So you wouldn't want to have a provision that allowed unlimited contact because it can be weaponized against you. But you would want to have something like the children can have access to phones and contact with their other party as reasonable, and frequency and timing can be limited, or something like that. And then in terms of parenting time, she said, how do we get them to do it on time? If at all possible, you want exchanges to happen at school or at daycare, because there are time limits imposed. There are boundaries that are imposed not by you. The school says what time the kids need to be picked up. If they don't, there's consequences. So that's what I would suggest.
Okay. How is the course structured? Is it a video course, series of lectures, written material?
You want to take that one?
So the members area is divided into the different types of cases. And as a member, you'll have access to all of the different types of cases. So there's divorce and legal separation, there's establishment of custody, and then there's custody modification, which includes modifying child support. And then there is the enforcement and information about contempt and orders of protection. So within each section, you would go into whatever category of case you have, and then that is structured from start to finish. So it's like numbered 1, 2, 3, 4, 5. And so number 1 is creating your case strategy, and there's videos and materials within that chapter. And then chapter 2 is about initiating your, or actually, I think chapter 2 is about seeking to engage in negotiations before you file. So that's not always a viable option for everybody, but it is for some people. So I walk through how to engage in negotiations for if you want to try to settle the case before you even file. And then in chapter 3, talk about the steps to initiate your case, drafting the papers, getting them filed with the court, serving the papers. And then after that, we get into the next steps after service is completed. Also talk about default, if that applies in your case. And then we get into disclosure and discovery, settlement negotiations, preparing for trial. So within each category of case, all of these various topics are covered basically in the order that you would encounter them in your case. And this is a lot different because if you explore other types of services that are seeking to help self-represented parties, they usually just offer something that addresses one step of the case. So, okay, here's how you initiate the case, and then that's all you get. But just having your case initiated, certainly that adds some benefit, but then what do you do after that? And at Win Without Law School, we offer comprehensive help from the start to the finish.
Lots of questions about that download. I went ahead and put that into the chat so you can download that there. Another question we got is, if we sign up for Essentials, can we upgrade at a later time? Let's talk about how that would work. So let's say you sign up for the annual Essentials today and you think you might not need to go to the live webinars yet, and later you want to upgrade, you'll be able to pay the difference, but the term will go back to the beginning of the Essentials.
If I sign up for a membership and take my ex to court for enforcement, can the cost of membership be included in legal fees if awarded?
That's a great question too. So I know that there is specific language that people use to request their fees when they have used a legal document preparer in Arizona. So there is a statute that allows you to recoup fees associated that are not lawyer specific. So that's what I would encourage you to use, but I can't tell you that I know the answer definitively. I don't know if a judge will include it, but there's nothing that stops you from asking.
If you are farther along in your case, are you able to pick up and choose some parts and sign up for them individually?
Love that question. You as a member have access to everything. We are not limiting access to members, but you can choose exactly what's relevant to you.
Right. So if you sign up, you get access to everything. And then you would be able to just connect with whatever part of your case you're having questions on or where you're at in the process. Can my ex request uninterrupted weekends and I have to give back time due to kids' activities?
Okay, I understand. So listen, in a negotiation, anybody can ask for anything. So if your ex is only getting weekends and he says, listen, I really want full, I'm assuming it's he, but it could be she. She says, I want full weekends. If Susie has a soccer game, I want to be able to get that at makeup time. Then you have to decide whether or not that's a deal you want to make. You can make that deal. It would never be ordered by a court. Parenting time includes like parenting, which includes activities. Like none of us have uninterrupted parenting time. So, but I don't know what's happening. So if your co-parent is coming from out of state, this is just a very personal decision. And we, if you were a member, would get into the details and really troubleshoot that with you and find out, is that a workable thing for you to agree to? Is it worth it to get the deal or the other things that you could get from making this deal?
When I testify and the opposing counsel says non-responsive, is that bad for me?
So non-responsive is an evidentiary objection, and we will teach you about objections in the members area. You will learn what objections you can make, what objections they can make. What does it mean when a judge says sustained or overruled? What must you do if someone says non-responsive? Well, you wait for the judge. The judge will tell you what you need to do.
Child has the flu and severe asthma. He should be at home. However, he's in dad's care and dad currently has him at the barbershop. Is there anything that can be done?
Does your court order say anything about this? Probably not, right? Your court order probably does not say when, if the child has asthma or when the child has asthma. So this is a judgment call. As you know, Mom, I've had kids who have asthma. It's a judgment call. How bad are they? Can you take them out? Do they need to be at home? Have you given them a breathing treatment? Does he have the equipment he needs? So only if this is a chronic issue of neglect do we get to talk about legal decision-making and parenting time. But is there a quick fix? Absolutely not.
What happens when you're in a high conflict custody battle, but both children are very young and one is special needs?
I really feel for you. This is probably our last question of the day because it's going to take a little bit of time. I think everything that we talked about here is so relevant to you. You are in a very, very, very long-term situation, and the decisions you make now are going to have impacts forever. And this is probably not the only time that you're going to be having the conversations that you're having, but it's so individualized, right?
Right. Certainly you'll want to put a lot of time and effort into the terms of your parenting plan to have them match up with the needs of your children. Certainly a parenting schedule for a 15-year-old is going to be different than one for a 4-year-old. Also, a parenting schedule for a child with special needs will be different than one for a child with no special needs. And also realize that the parenting plan is going to change over time. So what you put into place now and what could apply for the next year or two, you may need to go back and change because of the kids becoming school age, for example, or, needing different services. So understand that what you do now, even though when it becomes an official court order, it's in place until it's modified, that you're likely going to need to go back and modify it. And certainly if you're able to open up a line of communication and get an agreement about the modification, that's much easier than going through a contested battle. But overall, when you have a parenting plan entered and the children are young, it's going to need to change as the kids get older.
Thank you all so much for joining us today. We hope that we see you in the members area. Happy Hanukkah, happy Christmas. Have a great holiday, and we'll talk soon.
Thank you guys. Bye.